And right on time, Bonnie Yates, special education attorney, is joining us. I was afraid I wasn't going to get done in time, but she's here. Bonnie, they are already excited to be here and want to learn what you have to teach us today. Bonnie Yates is a special education attorney with the Tollner Law Offices, and it is our privilege to have her join us. Bonnie, how are you?
I'm good. I'm good. Thank you.
All right, tell us just a little bit about Tollner Law Offices and give us your disclaimer.
Okay, so Toner Law Offices is a 7 attorney firm. We're based in San Jose, California, with offices in El Segundo and Irvine. We do pretty much everything that you might need us to do if you had a child with a disability. So that includes not just IEPs and special education, but also discrimination under Section 504 of the Rehabilitation Act and the ADA. We do regional center stuff. We do some higher education stuff for students who need accommodations in a university setting. The disclaimer is that we are giving general advice to you about your rights under state and federal law, not a substitute for a consultation with an attorney. If you need a consultation with an attorney and you're in the state of California, you can go onto the Tollner Law Office's website, fill out a form, and you will be set up with a complimentary consultation. If you're in other states and you need the same thing, I suggest you go to www.copa.net and look at their attorney list. They have a list of good and committed attorneys. So that's all of that. What we had talked about was, is there something parents can do to improve their legal position when they have a dispute with the school district? And I kind of threw out something, and I was like, well, yeah, they could file their own due process complaint. And Shannon was like, really? But really, how would they do that? So I had a couple weeks in between when we discussed it and now to sort of think about whether my offhanded suggestion was actually something that was worth exploring further with you. And I decided it was. And the reason I decided it was is because when you go in and meet with the school district and you start getting pushback, the thing that you can say to them is, I'm in the process of, or I have consulted with an attorney. They've given me a sense of what my case is worth, but they've also indicated how much they would charge me for representing them. I'm prepared to do that if we can't resolve this successfully between ourselves. However, if we're not able to resolve it successfully, the cost of the case is going to get much more expensive because I'm going to have to spend more money. And I know that means you have to spend more money. So that's kind of the threat that I think people should trot out. We could talk a little bit more. I guess I'm not supposed to say threat. The position that people relate. Um, so let's talk a little bit about what due process looks like. Now, I did this under California law because, gee, why? Because I'm in California. Some of you aren't. So you can go in and you can look at the federal rules on mediation and due process. They're really California, I'm sure, tailored theirs based on federal law. So I think what you're hearing today would be similar to what exists under federal law. And for your own state, if you look at the state hearing office in your state, they should have information for you about due process procedures. Also, when you get your parental safeguards at your district IEP, the procedural safeguards do include discussion about mediation and due process. So some things that I think you could do preparatory to actually initiating due process, okay? One thing would be to try to do a little evaluation of your case and get a sense of what the district might have done that's wrong. I have certain clients, they're pretty attuned to their kids and they're pretty attuned to like smoke signals, even if they don't know exactly what the smoke signals are saying. But, they call me and they say, I think something's really wrong with what just happened. And they kind of describe it generally. I think if you're having a feeling like that, you might have isolated a violation, even if you don't know how to articulate it. Okay. So Special Education Rights and Responsibilities, SERR, is a very good general book about the IDEA that you could look at. to get a sense of the process generally. And then for your case evaluation, obviously what you're going to want to be able to do is articulate issues that you think constitute violations of the IDEA. So how could you issue spot? Well, I'm not saying you want to make a federal case out of it, but if you do, you can call the Special Education Hearing Office in Sacramento and you can get from them the decisions every month emailed to you, and you can read those decisions. And really, that's what the lawyers do too. We read the decisions, we get ideas, we see how the law is being articulated, and we bring all that to the table when we file for due process. And in terms of like having a gut feeling that something is bad, but not exactly knowing how to attack it. Attorney Valerie Vanneman, who's a very fine attorney and has done this almost longer than anybody, sent me a decision of hers against LAUSD that she won on, and she raised the issue of the frequency band. Now, frequency band is something that says he will receive OT 1 to 5 times per week at the frequency of X. And there's no way from looking at the IEP document for you to tell whether you're getting 100 minutes of service or whether you're getting 20 minutes of service. And she was really bothered by this issue, and she waited for the right case and she raised the issue. And I was like, darn, like I knew, I had a gut feeling that the way that is written, it can't be right. I should have raised that issue. So the point is, you learn a lot of good things by reading or even skimming decisions. And when you read decisions, like when I read decisions, I look and see who the judge is. I look and see who the opposing counsel is. And then I go all the way to the end and I see what the judge ruled on. And then I back up and I look at the issues that I'm interested in. But I don't spend an hour reading each one of these decisions. But there's a lot of information in them, and it's not a bad idea to look at some of those. Also, as you know, under state law, you're entitled to your child's educational file within 5 business days of getting written notice to the district. And so you might want to get the complete records and the service logs. Like I have a client who's trying to figure out how much ABA supervision she missed during school closure. So one way to get at that would be the service logs. Think about whether you need an independent educational evaluation at district expense, which I've covered in other programs. And if you're really going to go to due process, you probably do. But if your real plan is you're going to try to sit down and negotiate with these people, and then if it doesn't go away, you're going to hire an attorney. Your attorney can worry about all of that later. So why do I think this is going to work? Well, I think that
Bonnie, can I ask a question? Because we had this question come in about something you just talked about. Can we get the contact in? Where do you get that email for the special education hearing office so that somebody can get it mailed to them? Okay, she'll forward it to me and I'll post that.
Yeah.
Okay, sorry to interrupt, but that
No,
was
that's
pretty.
all right. That's all right. So why do I think this will work? Okay, 2 reasons. First of all, because I think the districts are poor right now because of their budget cutbacks as a result of COVID. And I think they are looking to make quick settlements for less money if they can. Why? Because I think the districts have acknowledged in like private trainings and things like that, or stuff I read you off of LRP, that they suspect that they have liability for every student who has an IEP during the period of school closure. So I've just sort of made up a number for myself. I think the districts are willing to give $20,000 or $25,000 potentially and attorney's fees without a due process filing for me. Like they will, I'll write them and say, hey, are you interested in a settlement without a filing? And they say yes. So I don't know what that number would be for you, but there's definitely money on the table. Okay. Although some districts are just kicking the can down the road, others are not. Some of them are just
So Bonnie, are you saying that we don't want to say threat, this action of saying I'm going to file due process and have legal help if you don't do this, that basically what you're putting on the table is this is going to cost the school $25,000 if they don't come to an agreement? Is that what you're saying?
Well, I'm saying that that's what I'm doing, and the fact that I'm getting positive responses suggests to me that the district knows they have tremendous liability, especially for the first semester of school closure, and that if they can make some settlements that are quick and dirty, um, that they're willing to do that. What I'm suggesting for you, though, parents, no, is I'm actually suggesting that you file a due process or you initiate some kind of due process procedure because your position is different than mine. When I write this attorney, she knows that I'm capable of filing a due process and going to hearing, and that influences her decision. Okay,
Okay.
so um, how can you threaten them with an attorney if you don't have any money? Well, it turns out that there are attorneys in the state of California that will provide low cost or no cost representation. So, in addition to getting the hearing decisions, which I'm going to show Shannon how that's easily done, the 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 Office of Administrative Hearings for the state of California and the other states has a list of attorneys that do low cost or no cost representation. Okay, so whether you can get one of those attorneys and whether you like the way they practice or not is a different issue than what you are conveying to the school district when you tell them you're going to get an attorney, because the school district knows that people that have very few resources, if they're tenacious, can still find an attorney to represent them. And those cases cost the district money because they have to hire an attorney as soon as you bring an attorney. So you definitely, can, as a first step, tell the district that you intend to seek legal representation if it's necessary and you're aware that it's available, but you want to see whether everybody can sit down without, a lot of rancor and stress and everything and work things out. But so it's kind of like a what we would call in the old days a veiled threat. You're not going to threaten them. You're just going to say, "Hey, look, I'd love to settle this with you. It'd be better for all of us. It'd be faster. It'd be cheaper. But I'm also aware that if I can't, I'm going to be able to secure an attorney to represent me." Anyway, so here's the stuff that I want you to know about, okay? Because all of this stuff is written down and you can look at it. Um, California Education Code 56500, that begins the whole section kind of on your procedural safeguards and your due process rights, okay? So take a look, and there's no magic in this. All you have to do is go in and put California Education Code 56500, and you will get um, immediately redirected to, I think it's like California Ledge Info dot something rather. I forgot what it's called, but you will get automatic immediate access to that section. You do not need to have Lexis or Westlaw. And if you look at section 56501, it talks about when filing for due process would be important. Now, why does this matter? Because OAH, the Office of Administrative Hearings, has only has jurisdiction over certain types of matters. So examples of things they don't have jurisdiction over. They don't have jurisdiction over permit appeals. So if you're attending a district special education program on a permit and the district tries to take your permit away, OAH can't get involved in that. OAH cannot decide claims brought under Section 504 or the ADA. They have jurisdiction in certain situations only. So let me tell you what they are, because it's going to cover everything pretty much that you have. The first is there is a proposal to initiate or change the identification, assessment, or educational placement of the child, or the provision of a free, appropriate public education to the child. Or there is a refusal to initiate or change the identification, assessment, or educational placement of the child, or the provision of a free, appropriate public education to the child. That language might be very familiar to you. That's the language that's in the prior written notices that you've been getting, because the districts have been sending out so many of those since school closure. Um, so if you look at that language, a proposal to initiate or change the identification, so that means if the district proposes or refuses to change your child's eligibility, that's a due process issue. If the district proposes to initiate or change something about an assessment, That's a due process issue. So due process deals with inappropriate assessments. Educational placement, well, that really includes goals, services, and placement. And that's something else you can raise in your due process. So basically, your due process is going to look at, um, most of the time, you're not going to have an eligibility dispute. Most of the time, you're going to have a dispute about goals, services, placement, right? And so if you file a due process hearing request and you raise issues related to goal, service, or placement, you or assessments, you're going to have a due process that's within the jurisdiction of the OAH. Okay, so that's
Got two quick questions for you. Somebody wants to know what is the difference between a district IEP and a school IEP? Are they the same?
none, no difference.
Okay. And then we do have a lot of people who've written in the last year and said that even though their child has an ASD diagnosis, they were deemed not eligible for an IEP. So if you don't
Yes,
actually have the IEP
yes,
yet, you can use due
yes.
process okay.
Yes,
Great. Thank you.
and that comes under, there is a proposal to initiate or change the identification. So
Okay.
in other words, if you have an initial SST meeting and the district does an assessment and they come back and they say, I know you have autism and we're going to offer you a 504 plan, you can appeal that decision to the special education hearing office.
Oh, we
Okay.
just have districts who are saying we see no educational need in your child, even
Well,
though they
okay, I think we did talk about educational impact on the show, and it's not the same as academic impact. And maybe we need to have another show where we just talk specifically about educational impact and or prior written notice, which is kind of a hot topic these days. But for right now, I'm willing to like put my money on the fact that if you have ASD, you should qualify for an IEP. I've always maintained that having a little bit of autism is like being a little bit pregnant. I'm not saying it's not easier if you have a little bit of autism than if you have a lot of autism, but I think if a district says you have a little bit of autism, it's not going to have an educational impact. I've never yet had the experience where I've sent a professional into the classroom and they haven't seen educational impact. Part of what's frustrating about this is that the districts select for kids that are on perfect behavior, don't talk to anybody, and just sit there and do their work like little, machines or something. But that situation is one in which the child should be interacting with other children and their teacher. They should be getting into some mischief, you know. So I mean, what I've seen where the district says there's no educational impact, what they're really saying is, I can get this kid through. I can pass him on from grade to grade. He's not a behavior problem. If he's not a behavior problem and he has at least average cognition, they're going to try to minimize his educational needs and the educational impact of his disability. But my experience has been that if you look at it, you're going to be able to find the educational impact. Anyway, um, under this section, okay, so that those are the grounds for due process, okay, and as part of the rights that you have under the education code, you have the right to a mediation. So that's one thing we're going to talk about. And you have the right to request that at any point during the hearing process. You have the right to examine pupil records. You have the right to a fair and impartial administrative hearing at the state level before a person knowledgeable in the laws governing special education and administrative hearings. You have the right to have the pupil attend the hearing. You have the right to open the hearing to the public if you want, because typically these hearings are private and they're closed. Okay, so if you're feeling intimidated at this point about your ability to initiate the hearing process, if you go to the California Department of Education website, they have a form you can fill out that's so easy. It doesn't require you to actually draft a complaint. It just requires you to do your best job that you can of articulating what the issues are. And generally, if you file that, that's going to get the process going. Now, the district does have the right to file a motion, and the grounds of the motion would be that they don't think that your pleading is sufficient to state a complaint under the IDEA. But all that would happen if they did that is you would just have to maybe tighten up your issues some. But my point is, I think most of the time when parents file these complaints, like I see them when I'm reading the OAH decisions, um, I don't see that the attorney is necessarily trying to get the complaint dismissed, because usually, the attorney for the district knows that sooner or later they're going to have to deal with this person anyway. Um, so when you file a request for due process, you have the right under section 56501.5 of the Education Code to have a resolution meeting. Okay, so the resolution meeting is a pre-mediation settlement meeting. And you're going to sit down with the district, and maybe some members of the IEP team, you're going to talk about what the problems are and what it takes to resolve your complaint. So that would be the first place you'd have a meeting with the district, and that would certainly be a place to make it clear to them that you've read your procedural safeguards, you understand your rights, you're in the process of interviewing attorneys to see who's going to represent you, but that if you could work this out without attorney involvement, you're open to that. Like, I don't think you should appear over eager, because as soon as you mention the word attorney, you're going to have the desired effect, and they're going to be like, oh God, you know. So put yourself in the district's position for a moment. If their operating concept is that every student with an IEP in their district is a potential due process because of school closure, they're pretty nervous. I mean, I've talked to a few attorneys that have indicated to me that they're nervous about this. Okay, so you can have a resolution meeting before your mediation, and the meeting shall include a representative of the local education agency who has decision-making authority on behalf of the agency. The meeting shall not include an attorney of the local education agency unless the parent is accompanied by an attorney.
Thanks for watching Autism Live. If you found anything helpful in this video, please give us a like. In fact, make sure that you smash that subscribe button on YouTube and give us a like on Facebook. You can also follow us on Twitter and Instagram for important updates. And please download our free podcast wherever you get your podcasts. See you next time. Until then, give your kiddos a hug from me and one for you too. Bye-bye for now. To subscribe, click here. And if you'd like to check out some more of our videos, click here.